There is a legal document that has existed in the United States for decades. It was not created last year. It was not hidden in a recent piece of legislation. It did not come from a new court ruling or a regulatory change. It has been sitting quietly in the American legal system for a long time, available to any qualifying senior homeowner who knows to ask for it. One document have ever signed it. That means 89% of the people watching this video who could be protected by it are not. Not because they made a mistake, not because they broke any rule, because nobody told them it existed. Here is what that document does. When Medicaid pays for a loved one's nursing home care, the program has the legal right to file a claim against that person's estate after they die, including their home, to recover what it's spent. This is called the Medicaid Estate Recovery Program. It is federal law. It operates in all 50 states. And in the last reporting year, it collected over $700 million from American families. Most of those families had no idea it was coming. The document I am going to show you today, when signed correctly, at the right time, with the right legal structure, is the single most effective tool available to a qualifying senior homeowner to stop that claim before it is ever filed. It does not require a lawsuit. It does not require a court challenge. It does not require a large sum of money. It requires one document signed before the crisis begins, witnessed by 2 people, and filed with the right office. Stay with me for the next 25 minutes. By the time this video ends, you will know exactly what it is, who qualifies, when to use it, and the 3 mistakes that cause it to fail, even when the family does everything else right. Take a man named Robert. He is 74 years old. He spent 31 years working for a manufacturing company in Ohio. He and his wife Margaret raised 3 children in the same 4-bedroom house they bought in 1987 for $0.6s, $94,000. By 2024, that house was worth $340,000. It is paid off. It is theirs. It represents everything Robert and Margaret built. In January 2024, Margaret was diagnosed with moderate-stage Alzheimer's disease. Within 8 months, her care needs exceeded what Robert could provide at home. In September 2024, she entered a memory care facility near Columbus. The facility cost $9,200 per month. Medicare covered the first 20 days. After that, Robert paid privately. By month 4, their savings, $87,000, were almost gone. Robert's daughter, a 47-year-old nurse, helped him apply for Medicaid. The application was approved. Medicaid began covering Margaret's care. Robert went home. He believed the crisis was over. He did not know about the letter that would arrive after Margaret died. 18 months later, Margaret passed away. 6 weeks after her death, Robert received a notice from the Ohio Department of Medicaid's Estate Recovery Unit. The state had paid $198,400 toward Margaret's care. Under Ohio's estate recovery program, it was now filing a claim against Margaret's estate, which consisted primarily of her half-interest in the family home. Robert had 30 days to respond. The house where he had lived for 37 years, the house where his children grew up, where his grandchildren visited every Christmas, was now the subject of a state collection action. Robert is not a rare case. He is the rule. There is one document, properly signed, properly timed, properly structured, that could have prevented that letter from ever being sent. Robert had never heard of it. The document is called a ladybird deed. The formal legal name is an enhanced life estate deed. It is not new. It has been used by elder law attorneys in the United States since the 1980s. It takes its informal name from an anecdote involving President Lyndon Johnson, who allegedly used a version of this transfer to convey property. The nickname stuck. Here is what it does, stated as plainly as I know how to state it. A standard life estate deed transfers your home to another person, your children for example, while allowing you to live in it for the rest of your life. The problem with a standard life estate deed is that once you sign it, the property is technically theirs. You lose control, you cannot sell it, you cannot refinance it, you cannot change your mind without their consent. The ladybird deed solves that problem. It conveys the property to your named beneficiaries, your children, your grandchildren, whoever you choose, upon your death. But during your lifetime, you retain complete control. You can sell it, you can mortgage it, you can change the beneficiaries, you can revoke the deed entirely. It is as if you still own it outright, because for all practical legal purposes you do. And here is the part that matters for Medicaid. because you retain that enhanced control during your lifetime. Most states, including Florida, Michigan, Texas, Vermont, and West Virginia, classify the property as still being in your estate for Medicaid eligibility purposes. You get to stay in your home. You do not lose it as an asset. But at the moment of your death, the property passes directly to your beneficiaries outside of your probate estate, and Medicaid Estate Recovery only reaches assets that pass through your probate estate. Read that again carefully. The property passes directly to your children at the moment of your death, bypassing probate entirely. Medicaid's estate recovery program in states that recognize the Lady Bird deed has no claim on it. The house Robert and Margaret built over 37 years, 0.6s, protected by one document signed before the crisis, filed in the county recorder's office for a fee of less than $50. Robert never knew this document existed. His family's attorney, a general practice lawyer who handled the will and the power of attorney, did not raise it. The Medicaid caseworker who processed the application certainly did not raise it. Nobody raised it because the system has no incentive to raise it. Let me show you what this document is actually worth in real numbers. The average nursing home cost in the United States in 2026 is $9,034 per month for a semi-private room. For a private room, it is $10,025 per month. The average length of a nursing home stay is 2.5 years. At $9,034 per month over 30 months, Medicaid's exposure in an average nursing home case is time = 0.6s, $271,020. That is the number that Medicaid's Estate Recovery Unit is authorized to pursue against your estate. Now consider what the Lady Bird deed costs. An elder law attorney in most United States markets charges between $50 and $500 to draft and file a Lady Bird deed. In some states, the document can be prepared for less. The recording fee at the county office typically runs between $50 and $5 and $75. Total cost, in the worst case, $575. For $575, correctly timed and correctly executed, a qualifying family can place their most valuable asset, in most cases the family home, outside the reach of a $271,000 estate recovery claim. The return on that investment is not a percentage, it is the house. Now I want to be precise, because this is a legal matter and the specifics are important. The Lady Bird deed does not make your home invisible to Medicaid for purposes of the eligibility determination while you are alive. If you are applying for Medicaid long-term care benefits, the rules about what counts as an asset are separate from the rules about estate recovery. We are talking specifically about what Medicaid can claim after death. In the states that recognize this deed, the home passes outside probate, and estate recovery cannot touch it. The 5 states where Lady Bird deeds are most clearly recognized are Florida, Michigan, Texas, Vermont, and West Virginia. A number of other states allow similar instruments under different names, the transfer on death deed, the beneficiary deed, that achieve a comparable result. Some states permit none of these instruments and require other planning tools, typically the Medicaid Irrevocable Trust, to achieve comparable protection. Your state's law matters, which is why I am going to tell you exactly how to verify your situation without spending a dollar. But first, let me tell you about the 3 mistakes that cause this document to fail. Because finding the right document and signing it is only part of the story. Before I walk you through those 3 traps, I want to say something directly. If this is the first video you have ever watched on this channel, you need to subscribe right now. Every week we publish one more piece of the Medicaid planning system that the system itself is counting on you not to know. The Lady Bird deed is one piece. The 5-year lookback is another. The spousal impoverishment rules. The Medicaid Irrevocable Trust, the observation status trap. Each one of those videos is the equivalent of what you just learned, and we are posting them every single week. Hit subscribe, turn on notifications, and tell one person in your family to watch this video today. Now, the 3 traps. Trap 1. The timing problem. The Lady Bird deed is not a crisis tool. It is a planning tool. If your parent has already applied for Medicaid, if they are already in a nursing home and Medicaid is already paying, the deed can still be signed. But its effectiveness at that point depends heavily on your state's specific rules, the timing relative to the application, and whether a lookback issue is triggered. The 5-year lookback is a separate rule that we have covered in depth in another video. The short version: Medicaid examines 5 years of financial transactions before the application date. Certain transfers of property during that window can create penalty periods. The Ladybird deed is generally not treated as a disqualifying transfer in states that recognize it, because you retain control of the property during your lifetime. But this varies by state and by how aggressively the state's Medicaid program interprets the rules. The bottom line on timing: the earlier you sign this document, the cleaner the protection. Ideally, it is signed years before any long-term care need arises. If you are watching this video and your parent is still healthy, this is the conversation to have today. Trap 2. The wrong state. Ladybird deeds are not recognized in all 50 states. The states with the clearest statutory or case law recognition are Florida, Michigan, Texas, Vermont, and West Virginia. Several other states permit transfer on death deeds or beneficiary deeds that achieve similar results. Some states permit none of these instruments and require other planning tools, typically the Medicaid Irrevocable Trust, to achieve comparable protection. If your parent owns property in a state that does not recognize the Ladybird deed, signing one will not protect the home. You need to know your state's law before acting. I will tell you exactly how to find out, for free in a moment. Trap 3. The probate bypass fails. This is the most technical trap and the most dangerous one, because it can cause a family to believe they are protected when they are not. 4. The Ladybird deed. To keep the property outside Medicaid's estate recovery reach, the property must actually pass directly to the named beneficiaries at death, without going through probate. There are situations in which this can fail. If the named beneficiary on the deed predeceases the owner and no alternate beneficiary is named, the deed may lapse and the property reverts to the probate estate. Medicaid recovery attaches. If the deed was not properly executed, incorrect, notarization, missing witnesses where required by state law, recording errors, it may be void or voidable, and the property will pass through probate as if the deed never existed. If the owner took out a mortgage or home equity line of credit after signing the deed without properly addressing the interaction with the deed, complications can arise that a state estate recovery unit can exploit. These are not hypothetical risks. They are the specific failure modes that elder law attorneys see regularly, and they are precisely why a $300 attorney consultation to review this document is not optional. It is the most important $300 in this entire planning process. The document is simple. The execution must be exact. For families in states where the Ladybird deed is not available, or in situations where the timing makes it less effective, there are 2 primary alternative tools worth knowing. The first is the Medicaid Irrevocable Trust. This is the most widely used Medicaid planning instrument in the United States. You transfer your home and other assets into an irrevocable trust. The transfer starts the 5-year lookback clock. After 5 years, the assets in the trust are outside Medicaid's reach for both eligibility and estate recovery purposes. The trade-off: once the assets are in the trust, you cannot take them back. You can retain the right to live in the home and to receive income from the trust, but the principal, the home itself, belongs to the trust. Cost: typically $2,000 to $4,000 with a qualified elder law attorney. Compared to the value of the asset being protected, this is almost always the right investment to make. The second is the transfer on death deed. In states that allow it, this instrument achieves a similar result to the Ladybird deed. Property passes directly to named beneficiaries at death, bypassing probate. The primary difference is that most transfer on death deeds are revocable during life, meaning you can change your mind, but you may not retain the same degree of control over the property that a Ladybird deed provides. The key point: there is almost always a tool available. The tool that is right for your family depends on your state, your timeline, your asset structure, and your specific planning goals. The next section tells you how to find the right professional guidance without paying for a consultation you have not yet decided to make. Here is the free practical action step. Step 1. Search your state name followed by the words Ladybird deed or your state name followed by transfer on death deed real property. The first page of results will tell you within seconds whether your state recognizes these instruments. Look for results from state bar associations, state government websites, or established elder law firms in your state. If the first page shows multiple elder law attorneys in your state discussing this document, it is recognized there. Step 2. If your state does not appear to recognize the Ladybird deed, search your state name followed by Medicaid Estate Recovery exemptions and then your state name followed by Medicaid Irrevocable Trust. These searches will surface the relevant planning tools for your specific state's rules. Step 3. Write down 3 questions before you spend $1 on legal advice. First, does your state recognize the Ladybird deed or an equivalent instrument for Medicaid? Estate recovery protection? Second, is my parents' property currently subject to any Medicaid lookback concerns? Third, what is the optimal timing for signing this document given my parents' current health status and any pending Medicaid applications? An elder law attorney, specifically an elder law attorney, not a general estate planning attorney, can answer all 3 questions in a single hour-long consultation that typically costs between $200 and $400. The answer to question 1 is yes, you sign the document at that consultation. The cost of the deed plus the consultation is less than $600. The asset being protected is worth, on average, $340,000 for American homeowners in this age group. Do the math. Step 4. Do not wait. If your parent is currently healthy, wonderful. Sign the document this week. The 5-year clock runs forward from the moment it is signed. Every month you wait. Is a month the protection is thinner? If your parent has recently received a diagnosis, move faster. The planning window is shorter, but it is not closed. The document can still work. You need an elder law attorney on the phone within the next 7 days. If your parent is already in a facility and Medicaid is already involved, call today. The options narrow as time passes, but there are almost always options remaining. The right attorney will find them. Let me bring this back to Robert. Robert's situation was not unique. It was not extreme. It was the ordinary outcome for an ordinary American family that did everything right, paid their bills, cared for their spouse, applied for the benefits they were entitled to, and still ended up with a state collection notice on their home because nobody explained the rules in time. The Ohio Department of Medicaid's Estate Recovery Unit was not acting illegally. It was doing exactly what the law authorized it to do. It was collecting money that had been spent on Margaret's care from the estate of a woman who had received that care. The program exists, it is funded, it has staff, it sends letters. It also has no obligation to tell you how to stop it. That is what this channel exists to do. The Ladybird deed, the Medicaid Irrevocable Trust, the 5-year lookback, the spousal impoverishment rules, the observation status trap, the caregiver-child exemption. Every one of these is a legal tool, already in the system, already available to your family, that most American families never learn about until after the crisis has already cost them everything. The best time to sign a Ladybird deed is 5 years before you need Medicaid. The second best time is today. I will see you next week. If this video helped you, share it with one person in your family, not because it helps this channel, because the person you share it with might be Robert, and they might not know they need to hear this yet. Stay sharp, stay protected, and stay one step ahead of the system that is counting on you not to.